See, Mr. Spies, you're the appellant, so I think you get to proceed first.
I am. Good morning. May it please the court, Mr. Chief Justice and members of the court, Ms. Wendel. I'm honored to be here to speak on behalf of Lawrence Lynch, Larry Lynch. It's also, of course, a very sad day to be in front of the court on such a grave matter. The facts, regretfully, are in no dispute in this case. Mr. Lynch today is 72 years old. He is a former president of the Johnson County Bar Association, former city councilor for the city of Iowa City. He has provided valuable community service throughout his lifetime residing in and practicing in Iowa City. He's provided pro bono services to a wide range of litigants and clients in Johnson County and elsewhere. He's now in the twilight of his career and is facing what he knows to be a separation from that career. I do want to clarify that we are not asking for a reprimand in this case. That was my mistake in a previous iteration of the brief in this case. We're asking for a moderate suspension that will be, for Mr. Lynch, survivable. He knows that he has harmed valued clients and he has harmed valued friends. He knows and has accepted responsibility for the violations of the rules of professional conduct in this case. That is not in dispute. In addition, he has recognized, as he testified in the hearing in this case, that the harm that he's inflicted on the Bells, both Daryl and Carolyn, and their son Tom and daughter-in-law Terry, is 10 times more burdensome to him than the death of his own parents. This is a tragic matter that he recognizes was inexcusable. As I said, the facts are not in dispute, with one minor exception. Mr. Lynch has been practicing in Johnson County for over 45 years. In the early 1980s, he began representing Daryl Bell. Mr. Bell was a farmer. He also had extensive business interest in Johnson County, and Mr. Lynch provided valuable services during the farm crisis, helping the Bells to escape the scourge of the farm crisis. He also provided representation to Daryl Bell in arranging and managing labor disputes involving agricultural labor. He helped Mr. Bell do some subdevelopment of some property that he owned in Johnson County and provided assistance in a variety of assorted business ventures that the Bells were involved in. By all measures, in fact, even the testimony of Carolyn Bell and Tom and Terry Bell, Larry was a very effective lawyer, professional, prompt, provided valuable services to the entire family. In about 2008, during the financial crisis that struck all America, Mr. Lynch found himself in financial desperate straits. He went to Daryl Bell, who was both a client and friend, and asked Daryl to loan him $90,000, which the Bells did by borrowing money from another financial institution, seeing that Larry got that money. During the course of the next several years, Larry borrowed an additional $75,000. All of this was witnessed by and memorialized by promissory notes, mortgages that Mr. Lynch gave to the Bells to secure the indebtedness that he had to them.
Here's what, go ahead.
Well, yeah, all fine and good, but the rules on these transactions are not of recent origin. There's been a fair amount of case law that's been cited by both parties. We've cautioned in the strongest of terms, I think, that it's a bad idea to get involved in business matters with clients. And it's clear that you have to, among other things, suggest independent counsel, and you don't dispute that. It's clear that there has to be written undertakings and so forth, and it's undisputed that didn't occur here. And here's a experienced lawyer. Tell me why he didn't know this. I mean, this has been in the environment for a long time, and then over a course of conduct, he has proceeded to violate the ethical rules. We know it's not very pretty, but it just seems to me, I'm asking the question, I mean, gosh, wasn't he aware of this stuff? And yet he still proceeded ahead and got himself where he is today.
You know, I pondered that myself, Justice Apple, and here's the best explanation I can give for it. I think that Iowa lawyers, and especially a lawyer like Mr. Lynch, who has dedicated himself, especially in a community where he was born and raised, where his children were born and raised, went to school, it's an embarrassment to have professional stature in a community where your mom and dad are living, where your relatives are living. The Lynch family is a huge family in Johnston County, part of the Irish mafia of Johnston County. And I'm sure that Mr. Lynch was blinded by embarrassment. He was blinded by anxiety and, to extent in the record, depression. He probably was reluctant to read the advance sheets. That's my psychological hypothesis, that you're absolutely right. The rules are crystal clear that there has to be written disclosure, there has to be written consent, there has to be written revelation.
It's not that, I mean, it's almost obvious. There's obviously a conflict here. You know, go see another attorney. I mean, you're encouraged to get independent counsel. And had independent counsel been engaged, there might have been different security arrangements, or maybe the transaction wouldn't even gone through, or maybe independent counsel would have said to Mr. Bell, you know, this is a risky thing.
Yeah.
You're way out there. Now, if you want to help your friend, you go ahead and help your friend, but I'm telling you, as independent counsel, that this isn't adequately secured and so forth. And, you know, then maybe we wouldn't be here today. But it strikes me as those are fairly obvious problems, and, you know, for a period of a number of years, and I don't know how many transactions, you know, your client drove through those.
Right, and the commission found, as will you, that this was an aggravating circumstance, that it wasn't just one transaction, there were several transactions, there were several renewals of those notes, and
Case law is just tumbling down, as you know, all during this period. It seems to me it would have ripened at some point, and,
getting back to your original question, the only other explanation I can give is that this was again a situation where there was a blurring of the lines between attorney and client and friend, and it's again undisputed that the Bells were friends of Mr. Lynch, that he was a friend of theirs. They went to family events together. They celebrated birthdays, anniversaries, and so forth. And while that's certainly no excuse, it could be an explanation for why the rules were violated.
Here's what bothers me about this case, in addition to the things that Justice Apple has raised. You know, this scenario, it's October 2008. There's the Lehman bankruptcy. You know, the stock market's going down the tubes. The real estate market's going down to the tubes. The economy is going down the tubes. People are being tossed out of work. And I just have a feeling that there's no other place where this person would have been able to get this loan other than from the client, and that if he had made the normal disclosures that he would have had to make to a commercial lender, financial statements, prior liens on the property, things like that, sort of demonstrating an ability to repay, there's no way he would have gotten the money. So there's a sense I have reviewing the record that he was kind of putting something over on the client, and that's what bothers me. Am I wrong?
I think that it's obvious that had the Bells obtained independent counsel, they would have asked the lawyer to do a lien search on the property that was being secured, being given security for the indebtedness. And certainly Mr. Lynch didn't volunteer that information to the Bells, notwithstanding the fact that they knew one another well, they knew their financial situation. The Bells were not as well versed, obviously, about Mr. Lynch's situation. But again, Darrell Bell was no novice. He was a sophisticated farmer, investor, real estate developer, and so forth. And I guess it would have been obvious to Mr. Bell, to Darrell Bell, that Larry came to him for a loan rather than going to a bank or credit union. Mr. Lynch represented the University of Iowa Credit Union until very recently, and those sources of funds were obviously not available to him. So the answer to your question is, yeah, was he preying on the Bells? No, I don't think so. I think that more accurately put, these are friends with means. He knew they had means, and he knew that the Bells would, out of friendship, loan him the money.
So client harm is one factor in we determine to weigh the appropriate sanction. How much does he still owe him? Is it still over the 160,000?
Yeah, 160,000 more or less. He has made regular payments to Carolyn Bell and lesser so to Tom and Terry Bell, but there's been no significant dent in the principal.
Given the fact that a lot of lawyers across the state will have these personal relationships, friendships with clients with means, is the 30-day suspension you suggest in your written filings a sufficient deterrent?
I believe it is, and the reason being that not only will he be separated from his practice, it's going to have ripple effects on his other clients who are have to get other counsel. More importantly, it's going to be in the Northwestern Reporter in the advance sheets. Every lawyer in Iowa or across the Midwest is going to know that Larry Lynch violated the rules. He suffered the consequences. Whatever creditworthiness he might have had is going to be exhausted and evaporated by virtue of him not having a practice. So it's going to be a significant blow, and he'll suffer it severely.
Thank you, counsel. Ms. Wendel.
Thank you, Your Honor. May it please the court and Spies. My name is Susan Wendel, and I'm representing the Attorney Disciplinary Board in this matter. And I'd like to address the Justice's question concerning whether the respondent knew about the conflict. He did testify at the hearing that he knew it was a clear conflict. And he did what he did anyway, and he did it multiple times. Over a 6-year period between 2008 and 2014, the respondent borrowed money 4 times from his clients. He executed 5 loan extension agreements, and he attempted to negotiate a release of the client's collateral towards the very end. He had 2 sets of clients. He injured 4 people, significant economic damage, $166,000 to 2 of them and $17,000 to 2 others, plus legal fees that they incurred when they tried to mitigate their losses.
What do you make of the claim that if we suspend him for a long period of time, he won't be able to repay?
He did make that claim. However, the record showed that there was not much attempt to repay before the respondent when he was active in his practice.
Let me ask you about the sanction. We had a case last year that seemed, it was a loan case, Peterson, and there were other things involved, but you probably know our cases better than we do, but given your job. But as I recall that case, she was ordered by the court, she was representing the executor, she was ordered to repay her fees that she had taken in on the estate. She didn't have the money. She borrowed it from the executor and repaid it that way. Had not repaid any of the money as of the date of the hearing, kind of similar to this. Mm-hmm. And she got, and there were other things going on, and she got 60 days. So how do we get from 60 days to 9 months in this case?
There are significant differences. We have a series of transactions here over 6 years. Peterson was a one-time transaction where she borrowed money from the executor to attempt to repay the fees to the estate that she did not have proper authorization from the court to take at the time that she received them. In this case, the respondent went back to these folks multiple times for more money and for extensions on the money that he already owed. And he established a pattern of conduct similar to Peterson in that he was just exhibiting and demonstrating a general indifference to his responsibilities to his clients and to the legal system as a whole. And he ended up causing significant economic harm to them and to their health as well. He was treating his client funds as a ready source for funding for his own purposes. And one of the justices raised the question of how this all came about, the respondent knew it was a conflict, and he kept going back and doing it. He had many opportunities when he could have disclosed his dire financial condition to the people that were loaning him money. At any time, he could have disclosed that. He could have provided adequate security for their loans. He never did any of that. And so it raises the question of whether he was in good faith in the very beginning.
Isn't it a fair interpretation that, like a lot of people in real estate, he was looking at everything through rose-colored glasses, that he wasn't justified in doing? He thought he'd be able to turn things around, and it wasn't realistic. Isn't that a fair interpretation?
Not given the exhibits that are in the record in the case that show delinquent property taxes on the property that the respondent gave to the Bells for security.
Let me try out another case with you. In that Weintraub case, we didn't impose our own suspension because the Nebraska Supreme Court had dealt with him already. But we said a 3 to 6 month suspension would have been appropriate.
Yes.
How does, and that was $275,000 unsecured loan, and you know, some similarities maybe to this case. How do we get from there to 9 months?
I think Weintraub is very different from this case because Weintraub made significant financial disclosures before borrowing the money. He told them his financial condition. In contrast, respondent in this case concealed it. All those years, he knew those people 30 years they were his clients, and they had no idea, none at all, that they testified that they had no idea that he was in any kind of dire financial circumstances.
Oh, wouldn't they? I mean, let me just ask it. Wow, the lawyer's coming to me, the client, for a loan. He must not have been able to get a loan on the ordinary market. Isn't that a fairly logical conclusion from a fairly sophisticated client?
Not necessarily. I would not describe the clients as sophisticated. Good farmers, yes. They had been in farming their whole life, and that was their primary business operation. Also, they saw Larry, or Mr. Lynch, as he described them, he saw them as friends as well, and he took advantage of that.
That all troubles me quite a bit. But as a farmer, he's pretty familiar with loans and collateral and banks and all this kind of stuff, I take it. Here's a lawyer coming to me for money. I mean, I'm testing the theory that the Bells must have had some knowledge that there was some stress, or he wouldn't be asking for a loan from them.
And he should have made full disclosures before he asked.
There's no dispute about that.
He also should have urged them to seek independent counsel before loaning him a penny. They did testify they expected repayment at the time the loans were made, that they didn't make gifts to him, and that it caused the family a lot of stress when it became apparent it wasn't going to happen.
One of the things that's really troubling to me as well, in so many of these cases, you're going to go to a client, regardless of the circumstances, because you feel that they have the means to loan you the $90,000 or whatever it might be at the outset here. But in this case, what I find more offensive is the fact that these people then don't have the cash there. They have to go out themselves and go borrow money from a bank during the middle of this financial crisis, and then they have to borrow it, and then they have to come up with the money to pay it back, and they still get nothing from the attorney here. And I guess it's more of an observation or a comment that makes it, to me, a little bit more of an aggravating circumstance than if I just have a couple $100,000 that's sitting in my bank and then I give it to you. Does that make any sense?
Yes, it is an aggravating circumstance. They had to pay interest on the money. They borrowed them. They had to hurry up and do it overnight. Everything was always a rush transaction. He directly and personally benefited from his misconduct. Even the collateral that he sold, their collateral that he sold, he used to pay off other personal debt rather than repaying the clients. And the commission findings noted that.
That seems to me like anytime you borrow money from your client, it's pretty much going to be for your benefit, right? How is that something that distinguishes this from other borrowing cases? I mean, it
Well-
wasn't Peterson, it wasn't Wintraub, right?
It's whether you intend to pay it back or not. And in this case, that is the big question. He certainly acted in his personal self-interest, and the clients are still out the money. And the commission found that the misconduct, the respondent's misconduct, had rendered the attorney-client relationship wholly vulnerable, that it reflected poorly on the legal profession as a whole, and that it warranted a suspension to maintain public confidence in the profession's ethics. And we would request that the court uphold the commission's findings and conclusions and uphold the suspension.
Thank you, counsel. Rebuttal, Mr. Spies?
Very briefly, Your Honor. I wanted to add that Mr. Lynch, despite the limited options he had available to him, did make an effort to not leave his clients adrift. He did provide security on all of these loans, albeit some of the security was insecure because of other indebtedness that was pledged on that collateral. But more importantly, he secured counsel to provide a workout plan to help untangle the real estate mess that he had gotten himself into, including efforts to protect the Bells through disposition of the property to the extent that he could, making arrangements with them through their counsel to liquidate the property, obtain releases necessary to sell the property. So again, to the extent that he was able to, he made an effort to soften the blow that he, of course, inflicted on the Bells and on himself. We again urge that a survivable sanction be imposed so that Mr. Lynch can carry out his obligation, an obligation he takes seriously, to see that the Bells in time are reimbursed. Thank you.
Thank you, counsel. The case of Board versus Lawrence Lynch is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.